All persons having business before the Honorable Associate Judges now presiding over the District of Columbia Court of Appeals, draw near and give your attention. God save this United States and this honorable court. This honorable court is now in session. Please come to order.
Good morning, everyone, and welcome to this remote session of the District of Columbia Court of Appeals. I want to begin by acknowledging that Judge Robert Okun is sitting with us today by designation, and we thank him very much for his help. We have two cases that we'll be hearing this morning. The first is number 19-CO0946, Darius Smith versus United States. And with that, we can turn to Ms. Persico. Good morning.
Good morning, Your Honors. May it please the court, I'm Deborah Persico. I'm here on behalf of the appellant, Darius Smith. The issues presented to the trial court in this case were whether the appellant's trial attorney investigated his mental health status and, given his documented intellectual limitations at the time of the plea, did his attorney adequately educate him about pleading guilty such that he understood the consequences of the plea and did not feel pressured to enter a guilty plea? Now, the assessment of both appellant's capacity to plead and his attorney's ineffectiveness was necessarily predicated on what and how his attorney educated him about the guilty plea. And yet, despite the trial court referring in all four subsections of its ruling on competency that the experts agreed that appellant could become competent if he was adequately educated, without any evidence whatsoever as to what the trial attorney told Mr. Smith and how he educated him, the trial court erroneously assumed that his attorney had advised him properly, and then found that even if he hadn't advised him, that the Rule 11 colloquy saved that. And third, that the appellant was competent to plead guilty. All of those, yes.
Sorry, I hear an echo. Do you hear it too?
Are you hearing, is it an echo or are you hearing a motor in the background?
Just an echo right now, but hopefully
I think,
you can hear
yeah,
me.
let's all mute ourselves if we're not speaking then.
So my question for you is, as you say, this case boils down to how the trial lawyer counseled his client, but the trial lawyer didn't testify. Mm-hmm. And it's my understanding that it's Mr. Smith's burden to call counsel. It's Mr. Smith's burden to show ineffective assistance. So I'm wondering what we do with that.
Well, I don't believe it is Mr. Smith's burden. Mr. Smith made a claim. His claim was that he was not competent to plead guilty and that his lawyer did not advise him properly given his limitations. That was his claim. He presented an expert opinion on the fact that he could become competent if adequately educated. It was then up to the government to disprove Mr. Smith's claim. So if they wanted to disprove that claim, they could have called the trial attorney, and the trial attorney could have said exactly what he did or did not do.
But that makes it sound like if a petitioner or a 23-110 movement testifies in one way, that we're supposed to presume that their testimony is true and then shift the burden to rebut it. I'm not sure that that's what our case law reflects. Well, I understand your client, well, your client didn't testify either. Your client put an affidavit in saying what happened, although I'm not sure that the affidavit even really addressed what his lawyer did or didn't say. Did it? I mean, what
No.
evidence was there in the record about what counsel did or didn't say? And isn't it Mr. Smith's burden to put on evidence that whatever was said was inadequate?
Well, Mr. Smith, first of all, didn't have a chance at the ineffective assistance portion of this. The trial court made a decision without holding any hearing that trial counsel did properly advise his client. And even if he didn't, the Rule 11 inquiry cured that problem. So the trial
Well, I mean, but didn't Judge Morin say, and this goes to Judge Easterly's question about whether anything was said in an affidavit or declaration, didn't he say there was no evidence in the record about what trial counsel said? In other words, didn't your client have an initial burden to say, look, my lawyer didn't tell me this and didn't tell me that? And that seems to be missing.
Well, in his affidavit and in the motion, that claim was made that the lawyer did not counsel him properly. Those claims were made. Now, so once a claim is made, if the government disputes that claim, then the government should present evidence disputing it, just like it did with Dr. Steskel's affidavit. Before the hearing, the government went and sought its own expert to dispute what Dr. Steskel said. So,
but wait, and you can correct me if I'm wrong, but I thought that essentially what was asserted in your client's affidavit was, I thought I would have to prove my innocence. I didn't realize that this or that. There were some specific things, and I'm forgetting exactly what. But now we're encountering an argument that counsel did not tell Mr. Smith the things he needed to tell him in order for him to become competent, which are some other things, it seems to me. So what examples can you give from his affidavit or declaration that he said something to put that genuinely an issue?
Well, the way that he put it, the way he put it into issue is in the claim, in the actual motion that was filed, the claim was made that he was not properly advised about the consequences of pleading guilty, given his limitations, and that because of that, he felt pressured. And he felt as if the attorney was telling him he would have served a much lower sentence. That claim was made. As far as the ineffectiveness part, that claim never made it to a hearing because the judge did not hold a hearing. Instead, the judge went directly to the competence issue. And the evidence came out at that competence hearing based on Dr. Steskel's testimony, based on 2006 records, based on 2012 records from the special education teacher, based on Dr. Steskel's testing of Mr. Smith, that Mr. Smith could become competent if his lawyer properly had advised him. At that point, once that claim is made, the government comes in. The defendant doesn't have to call his lawyer to say, he's lying. That's not true. I sat with him for 50 hours on this and explained it perfectly. It's not up to the defendant to try to disprove his own claim if the lawyer is going to say that that's not what happened. It's up to the government to then say, this is not how it happened. Here's the lawyer says, I spent 50 hours in, educating him. He knew exactly what was going on. That's up to the government to disprove Mr. Smith's claim.
So I'm wondering, I know that in the 23-110 motion, there's a request at the very end for a hearing. I didn't see anywhere else. Is your position that that's enough just to preserve the issue? Hey, we want a hearing. I mean, they go ahead and they have a hearing with the experts on the competency issue. And it just seems like that's just fine with counsel to do it that way. And Judge Morin notes in his competency ruling, both sides, the government moves to have access to talk to the lawyer. Presumably Mr. Smith is able to talk to, or his new counsel, post-conviction counsel, is able to talk to his lawyer. Neither side decides to put him on. I'm just wondering if this is really preserved in Superior Court.
Well, I think it is, because this was all one claim. This claim was Mr. Smith was not competent to plead guilty because his attorney did not properly advise him given his limitations, and therefore counsel was ineffective and the client was incompetent to enter a guilty plea. It's all one claim. It was the trial judge that split these things. So at the end of the motion where he requests a hearing, that hearing is to cover all of these issues. It was the trial court that for some unknown reason thought that it could be split. They could not be split. There was no way that a finding could be made on ineffectiveness.
Right, but you're sort of making my point. I mean, not being an expert trial lawyer, but it seems to me that you would want to put the lawyer on and confront them with your client's mental health, cognitive, developmental records and say, did you have these? Did you review these? How did you speak to the client? How many times? How clearly? And elicit that sort of evidence.
No, because listen to what you're saying. You're asking the client to possibly disprove his own claim. He makes a claim. This is my claim. My lawyer didn't properly advise me for whatever reasons. The government has to dispute that claim. If it feels it's not a good claim, the government disputes. It's like any other type of claim. The complainant doesn't have to put evidence on that potentially could totally disprove his case.
Ms. Persico,
Yeah.
I just want you said the government has to refute the claim, and I'm looking at this from the trial court's perspective, and I could see why the trial court had a hearing on the competency issue, because you had competing affidavits from different experts that couldn't be resolved by just looking at the paper. You needed to hear from the experts themselves and decide which expert you were going to credit more heavily. Whereas the ineffective assistance claim, there are claims there that the government didn't necessarily need to dispute because they were already refuted by the existing record. For example, one of the claims was that the appellant felt pressured to plead guilty because, according to his affidavit, his attorney told him he'd get 30 years if he went to trial. He'd get only 12 years if he pled guilty. So his attorney promised him a sentence and pressured him to plead guilty. And those claims are contradicted by the transcript of the plea hearing, where the appellant says he wasn't promised anything by his attorney. He wasn't pressured by his attorney to plead guilty. And I guess, so my question is, in that circumstance or in that context, why does the government have a burden to do anything other than to cite to the record, which refutes your client's claims?
The trial court could not possibly have decided that Mr. Smith was competent to enter that plea based on yes and no answers to lengthy paragraphs in a Rule 11 inquiry without knowing how the trial attorney advised him. The Rule 11 inquiry tells you nothing, and the expert actually said that, Dr. Steskel.
Well, one expert said that.
Okay, but there was evidence presented to the judge in that claim that the Rule 11 inquiry would tell him nothing. And if you look, the judge says he did this great Rule 11 inquiry. I disagree. If you look at that inquiry, he never asked Mr. Smith, Are you taking any medications? And we know from the record that Mr. Smith was on some type of drugs, at least for bipolar disorder. He didn't ask him what his education was, what his mental status was, no idea. He never stated the elements of the crime, never explained to him what the
Let me
elements-
ask you that about the elements of the crime. Is your argument that the trial court was required to explicitly go through the elements of the crime in order for the defendant to be informed of the elements of the crime? Because isn't that argument inconsistent with some of our own case law, which indicates that an appellant can be informed of the elements of the crime without the trial court explicitly going through the elements of the crime?
Well, first off, Mr. Smith was not indicted. So the formal elements of the crime were never laid out for him in an indictment. And I had cited the Gaston case, which said, and if you give me 1 second, I will find out where that is, in a DC case in 1988 that said that the judge should detail the elements in a particular crime when doing the Rule 11 inquiry.
So let me ask you this, though, going back even a little further, there's a case from our court, the McClurkin case, which is 472 A. 2nd 1348, which is a 1984 case where the trial court did not go through the elements. That was a murder case. And the court nonetheless found that the appellant was adequately informed of the elements of the offense. So I don't think there's a hard and fast rule. In fact, it seems to me absolutely inconsistent with McClurkin that there's a hard and fast rule that the trial court has to explicitly go through the elements of the offense in order for the appellant to be informed sufficiently of the elements.
Well, in this particular case where the judge never even asked the defendant, how far did you go in school? What is your educational level? Do you have any mental health issues? Are you on any medication? I would say he had better start giving more details to the defendant to make sure he understands. He didn't even ask Mr. Smith to recount on his own, give a factual account.
Is there any requirement? Wait, let me ask you that. Is there a requirement, because I'm not aware of any, that under Rule 11, the trial court has to ask the appellant to give a factual account of his own and cannot, because typically what is done in Rule 11 inquiries is that the prosecutor will give a proffer of the facts and the appellant, the defendant, is asked whether or not he agrees with that proffer.
Right.
Is that legally insufficient?
If we had a case where the judge had already asked the defendant, how far did you go in school? What is your educational level? Do you have any mental health issues? Are you on any medication? Maybe that would be fine. But I'm saying in this particular case, the judge did not have enough information about this particular defendant to just whip through a regular Rule 11 inquiry and expect yes and no answers.
Can I ask you a question about, I guess, prejudice or harm? I mean, is your argument that if your client had been adequately advised, he might not have pled guilty? And is that supported in the record? Or is your argument that your client was not competent to plead guilty and so therefore, or not competent to stand trial because he really didn't understand the proceedings?
No, what he was saying is that he was not properly advised given his intellectual limitations, and that had he been properly advised, he would not have pled guilty. So it's a combination of this competence issue, ineffectiveness issue, and that he would not have pled guilty, and he says that in his affidavit.
When he says, I'm looking just at the record copy, is that this is the affidavit from 2015. Is that the right affidavit?
Yeah, the one that he attached to the pro se motion.
So when he says, I only pled guilty because my lawyer threatened me. You're saying what he's saying is, and I wouldn't have pled if I had been adequately informed. I would have gone to trial.
Yes.
Because it doesn't, I mean,
Yes.
there's another step or two there that you would have to take from what he actually says in the affidavit.
Yes.
Do you agree with that?
I'm sorry. Yes, I think he was saying that had I been adequately advised, I would not have pled guilty. I did not understand what I was pleading to, and had I known then what he was learning at that point, I would not have pled guilty.
Ms. Persico, we will
Yes.
give you a little time on rebuttal if you need it. Let's hear
Sure.
from Ms. Heffernan now.
Okay, thank you.
Good morning. May it please the court, Patricia Heffernan on behalf of the United States. From my perspective, I think the court, I would encourage it to step back, because this is not one claim. These are two very different claims with different standards. The court had different evidence in support of the different claims. And so I think it's important to keep that in mind. We've got ineffectiveness claims and we've got competency claims. And before I go any further, I wanted to point out that at no point, there was never a claim that he should be permitted to withdraw his guilty plea because there was a fatal defect in the Rule 11 inquiry. So that is not before the court. Even though appellant is now criticizing the Rule 11 inquiry, that was not an independent basis for moving to withdraw the guilty plea. And the court pointed that out in the initial order denying the ineffectiveness claims when it did a manifest injustice inquiry and found none, and pointed out that there is no claim that there's a fatal Rule 11 defect. With respect to, and I also
Let me just interrupt 1 second,
Sure.
Ms. Heffernan. Just in terms of the manifest injustice argument, so I noticed on page 44 of your brief, you argued that the appellant needed to show both ineffective assistance and manifest injustice in order to withdraw his plea. And I'm just wondering, is there any scenario in which an appellant successfully shows that his lawyer was deficient and he wouldn't have pled guilty but for that deficiency, and yet it would not be a manifest injustice to maintain the plea?
nothing comes to mind.
Okay.
Yeah, I mean,
So
I
if you
think they're intertwined questions, and but I don't think that's the scenario here, because the court found with respect to ineffectiveness that appellant had not shown deficiency because his complaints are vague and conclusory. He talks about undue pressure without specifying what that pressure is. You know, when we think about undue pressure, we think about a defendant whose will has been overborne, and he doesn't flesh that out.
Ms. Heffernan,
Yes.
what about the argument, though, that he doesn't get a hearing, right? I mean, I find it a little troublesome that you have a claim, you say separate claims, but it seems to me that they're connected, and they're certainly put forward in one motion. That, you know, he received ineffective assistance of counsel and was not competent to plead at the time he did. And you have a hearing on half of it, but not on the ineffective assistance of counsel portion. And I'm just wondering, I mean, wouldn't the government be in such a better position if a hearing had been held and the record was as it is, right? Because then we could say, well, he had the opportunity to put on his evidence, and yet here we are, and the record is inadequate to support his claims. But if there wasn't a hearing and he wasn't given the opportunity to put on evidence to flesh these things out, I think, to use your language, then where are we now?
Well, the question isn't whether we would be better off, and you know that's debatable.
I guess
the problem was
as a court, it would make it easier for us to do our job as a court if we knew what the record was. But here we are, and there was only half a hearing.
Okay, and that's why I wanted to just emphasize that these are different claims, and I'd like to explain why that is. But starting with the ineffectiveness claims, these claims were just, he complained about undue pressure, and he didn't claim that my lawyer was ineffective because he didn't explain all of my rights to me. That was not a claim that he made.
Okay, but he's a person who's saying, I mean, his lawyer on his behalf is saying this person has cognitive deficits. So, I mean, for him to articulate it beautifully in his affidavit might not be the standard that we're
Oh, I'm not referring to the affidavit. I'm talking about the motion that his lawyer filed for him. His lawyer, the lawyer didn't contend in the motion that there's no freestanding claim that these rights weren't explained to him, and there were no representations made about the discussions that the lawyer had in the motion. And that's why I just want to, if I could, just for a moment, I want to address why I think it's important to separate the issues, because when we're talking about competency, the question is whether the defendant had the sufficient present ability to consult with his lawyer. It talks about ability. Is he capable of this? And both of the experts said he was capable about this. What Dr. Stejskal did was he went beyond answering that question to really considering whether the plea, I think it was knowing. I think he was answering when he starts talking about, when he said, neither expert disputed that the defendant was able, he had the capacity to consult with his lawyer. And that's the question that gets answered when we consider whether a defendant is competent. It's what is his ability, his present ability. It's a separate question whether or not the plea was knowing. And that's what I think Stejskal was talking about when he said, well, I can't find that it was. He terms it in terms of competence, but he's never saying he's incompetent. He's really, when he starts the discussion about what the lawyer told the defendant, that really is pertinent to whether the plea was knowing, not whether it was competent in the legal sense. And that's why
I thought the lawyer said, look, he didn't seem to understand the nature of the proceedings, and he could be educated about them, but he didn't seem to understand the nature of the proceedings, which does seem like a competence question, not a knowingness question.
Well, I think that's where the experts disagreed, and one expert, Stejskal said he was concerned about the trial mechanics, and Huguenet said that's not really the inquiry. We go way beyond that, and what I'm interested in is what is his decision making? How rational is he? And that's where Huguenet explained that he posited various scenarios, and that the defendant could appreciate with how his decision making with respect to pleading guilty would change depending on the scenarios. Were there cameras in the store? What does consent mean? And how would that be established? What is the weight of the DNA evidence? And at the end of the day, you had competing experts on the question of competency, and the court can't have clearly erred in crediting one. But I do want to say, I think I wanted to point out, because it's a funny way of framing competency by saying, oh, he's got the ability to understand these proceedings and to consult with his lawyer, but I don't know whether but I don't know what his lawyer exactly told him. He's not mentally incompetent or intellectually incompetent. I think Stejskal was answering a different question, and that's why everything gets sort of balled up, and it really should be, the thread should be pulled apart, because they're different inquiries with respect to ineffectiveness and competency.
So let me just follow up on that, because I understand that there are two claims, but I want to go to your argument that the ineffective assistance claim was not timely appealed. And I'm just wondering, isn't that argument inconsistent with the case law that discourages piecemeal appeals, especially here where there is some overlap between the claims? And actually, let me put it a different way. Are you aware of any case from this court where this court has held that an appellant must appeal a partial denial of a 23-110 motion or other post-conviction motion and cannot wait until the 23-110 is completely denied?
No, but I would point out, Your Honor, that what is being appealed is not the denial of the motion, it's the orders denying the motion. And we have two separate orders here. And so that's why they're procedurally distinct. And, we think that under Deloach, appellant should have filed a separate notice of appeal with respect to the ineffectiveness order.
Even though there are two separate orders, but they both relate to the same 23-110 motion, isn't that right?
Yes, but they're two separate, you can raise any number of different claims in a 23-110 motion, and there was, I don't think there was anything wrong with or improper with the judge disposing of the claims that he could dispose of on the record, because he thought I could dispose of these on the record. Procedurally, they're distinct. If, for example, if the court had received that appeal and thought, well, the court certainly could have held that appeal in abeyance pending the disposition of this other order if it had wanted to. But we, the government, we're not hanging our hat on this procedural argument. I think that the court's order denying the ineffectiveness claim should be affirmed, are easily affirmable on the merits. But I do think, the government has an interest in making sure these claims are timely processed.
When appellant's expert, Dr. I forget his name, starts with an ST. What is it?
Stedschkel, I might be mutilating
yes,
that.
Thank you.
But
When he said, or when he opined that appellant could become competent, had the capacity, but he wasn't sure what the lawyer told him, what was discussed between the two of them. Did that place some obligation on the trial court to go back and rethink its ruling on the ineffective assistance claim, sort of having highlighted before him the issue of what did the lawyer tell Mr. Smith?
I don't think so, Your Honor, because, well, first of all, there was no reason why. I wanted to step back for a moment. We had this order issued in January. The hearing didn't occur until, I don't know, maybe September or May. I'm mixing up my dates, but there were several months between this order. There was never any discussion by the lawyer about, hey, when this hearing started, for example, I know you've already found that counsel wasn't ineffective, but I think this hearing is going to have some bearing on that. So I'd like you to reconsider that. The court certainly had no sua sponte obligation to reconsider its order, and defense counsel if defense counsel thought that was appropriate, then defense counsel had the obligation to ask the court to reconsider that order in light of the evidence at the hearing. He didn't do that at the beginning of the hearing. He didn't do that when the hearing ended, and he didn't do that when there were additional pleadings filed. So I don't think that the trial court can be faulted for not sua sponte revisiting that. And I also wanted to point out again, there was no claim raised in the ineffective assistance of counsel motion that the lawyer had not advised him of his rights. He does complain vaguely about the fact that he wasn't properly advised, but properly advised as to what? There's no specification about what it is that there never has been, there is not now, what it is that the appellant did not understand when he pled guilty, and why it is that had he understood it, he would not have entered a guilty plea. I mean, I heard Ms. Persico was now saying that if he had understood the elements of the offense, he wouldn't have pled guilty, but we're hearing that for the first time at oral argument. And that's why the court rejected the motion, because it was a couple of vague claims about I felt undue pressure, but no specification about how the lawyer pressured him. I mean,
let me just ask. I mean, I think there is a specific claim in the affidavit. I mean, when appellant says that his lawyer told him he'd get 30 years if he went to trial and he'd only get 12, and he promised him 12 years if he pled guilty, isn't that a specific claim? And why is that claim not worthy of an evidentiary hearing?
Well, I think he didn't say, he said that the lawyer, I think he said you're facing 30 years. I don't think, even the way it was framed was not was not, my lawyer has A, absolute on this, and B, he said his lawyer told him that if he pled guilty, he'd get 12 years. And then he says, and then he goes on to say, my lawyer promised me 12 years. But those two statements were inconsistent. And all of this rings of a lawyer doing his best job to say, hey, this is what I think you're facing. Here's where I think you may come out. And so it does, there's no, he isn't really even making these affirmative allegations of threats and promises. And then again, as Your Honor pointed out, when push came to shove at the guilty plea hearing, he swore under oath that he had not been threatened or coerced and that no promises had been made to him. The court asked him if he had any questions. He said he did not. And so his own sworn statements belied the, what I think are not even concrete allegations in the affidavit.
But that, I mean, just looking at the guilty plea itself, if that were enough on its own terms, he would never be able to get underneath it with a 23-110 saying, actually, before we walked into the room, he told me X, Y, and Z, right? I mean, we can't just rely on what was said in the courtroom. The question is, what is the evidence about what happened, how he was advised, how he was counseled, what he understood. I'm looking at the 23-110 motion. I think I'm looking at the 23-110 motion, and the record copy is on page 11, and it talks about Mr. Smith's believing that he would be required to testify against himself and to prove himself innocent. Those seem to be fundamental misunderstandings about how this all works. No?
No, I agree that it would be a mistaken understanding to think that you had to testify. And even that it wasn't so clear to me when I read that, whether or not he thinks he needs to testify to prove himself innocent, given all the evidence against him. I mean, how is he going to get out from under this? He's got a complainant who's alleging that he raped her and DNA evidence. And, so that wasn't even so clear to me, but he never even asserted that, I pled guilty because I thought that if I went to trial, I was going to be forced to testify. I didn't want to testify. And if I had understood I didn't have to testify, I wouldn't have pled guilty. And as the court pointed out, there is no easy defense here in this case, given the facts. And so, not to go too far down this road, but I don't see how this notion that he would have thought he had so much of a better shot if he had gone to trial without testifying.
What does the government think about, resolving this on harm? Is that a viable avenue here, that he doesn't even actually say, I wouldn't have pled guilty. I would have gone to trial if I had been adequately advised. I didn't want to plead guilty. I wanted to exercise my rights to go to trial.
Well, I think that's an avenue. I think it's his burden of showing a reasonable probability that, but for, if we're going to focus on this particular misunderstanding, he would have not accepted the guilty plea, not pled guilty, not accepted the plea offer, and he would have gone to trial. And the court rejected that notion at page 10 of its order by finding that he admitted the offense both at the guilty plea proceeding, to the youth report writer, to the PSR writer. He's never asserted a claim of innocence. He got this great benefit by getting out of the armed element, which exposed him to a maximum of life imprisonment. And so he hasn't shown a reasonable probability that but for this alleged deficiency, he would not have, he would have rejected the plea offer and gone to trial. Hopefully that answers Your Honor's question.
Anything else you need to tell us, Ms.
If I
Heffernan?
may have one moment, I
Yes.
just wanted to review. No, I think I've made the points that I wanted to make. I just wanted to reiterate. I do think that these are they're different claims that need to be shouldn't be all melded together in a ball of wax, but should be pulled apart and the appropriate standards and inquiries applied. And I think that's why it makes sense what the court did, why it didn't, and why ultimately defense counsel didn't come back and say, hey, now let's revisit this ineffectiveness claim. If there are no further questions, we'd ask that both orders be affirmed.
Thank you. Ms. Persico, you can have 2 minutes. You're on mute.
Sorry about that. Okay. So first off, Ms. Heffernan mentioned that all they basically had to prove was that he was able to consult with his attorney. That's not correct. Under Dusky, there's 2 findings that have to be made. First is that there was a sufficient ability to consult, and second, that a rational as well as a factional understanding of the proceedings against him. So it's not merely can he consult, but did he have a rational understanding of the proceedings? So 2 parts to that question. Secondly, as to what's in this motion, Judge Easterly hit the nail on the head. If you look at pages 7 through 11 of Mr. Smith's motion, you will see exactly what was laid out, and he spells out that there were, that he failed to adequately explain his constitutional rights, okay, for the lawyer, and then also spells out that he, felt that if he understood his counsel to be telling him that he could get a much longer sentence. So those claims are spelled out in the motion. As far as Dr. Huguenet, our position is that his explanation is not plausible when you connect it with the facts in this case. And there's just 3 quick things I want to tell you about Dr. Huguenet's testimony and why it should have been rejected as a matter of law. First off, he says he interviewed Mr. Smith 6 years after the fact. And he said Mr. Smith understood his rights and all of that 6 years. Well, no surprise there, because for 3 years before that, Mr. Smith had discussed who knows how many times this case with his jailhouse lawyer. Then he was consulted by 2 consecutive 23-110 attorneys. And then he met with Dr. Stayskull, who says on the record, and the judge mentions this, that he educated Mr. Smith at that interview about Mr. Smith's rights. And secondly, Dr. Huguenet agreed on the record that the prevailing view among the psychiatric community is that transcripts are not evidence of competence. And yet, even though he agreed with that, he said he relied heavily on previous transcripts of pleas where Mr. Smith said nothing more than he did in this particular plea, just yeses and nos, that's it, where there was no evidence of how the attorneys in those cases counseled Mr. Smith before he got to those pleas.
I mean, just in terms of the transcripts, let me just say I know the grand jury testimony is not a plea, so there are some different issues, but clearly it wasn't just yeses and nos. Clearly there was an ability to follow questions, to answer questions, to elaborate on his answers.
But think about how grand jury testimony comes about. The defendant's lawyer discusses the case, discusses what he's going to testify to. Then they meet with the prosecutor. The prosecutor explains what he's going to testify to, and then they put him before the grand jury. So those steps are exactly what Dr. Stayskull was talking about, that he can become competent if he is adequately educated about a topic. And the other thing that Dr. Huguenot never even mentioned was that in 2012, the special education teacher at the jail reported that Mr. Smith had cognitive difficulties, needed to have information repeated to him lots and lots of times before he could retain that information. That 2012 report corroborates what they found in 2006 about his cognitive disabilities. So Dr. Huguenot's testimony is simply not supported by this factual record. And in fact, he was the only dissenting person. And in the Bruce case and the Macris case, that says that you can consider that that diminishes the force of his testimony. So we say Dr. Huguenot's testimony—
Actually, I'm just not sure. Let me just interrupt. When you say
Sure.
he was the only dissenting person, there is one expert on each side. And I understand you said, I guess there's a special education teacher who said one thing in 2012, but also DCPS did not say that at that time period. So I'm just not sure about the only dissenting person.
Okay, well, with DCPS, Dr. Staskell explained that they did not do the subset of testing for cognitive difficulties in that test, which they had done in 2006. And my point about the special ed teacher is that he corroborated what they said in 2006 about that subset of testing on cognitive difficulties. So my position is that Dr. Huguenot's testimony should not have been, should have been rejected as a matter of law in this particular case. And lastly, Mr. Smith did not have to prove that he would have won at trial had he gone to trial. And I'm sorry, I can't, the case is in my initial brief.
Not that he would have won, just that he would have gone to trial instead of pleading guilty.
Well, and he says that, but he does not have to prove that he would have had a great case at trial. What he has to prove is that he was not adequately counseled because of his competency issues. And had he been properly counseled, he would not have pled guilty.
But let me ask you, doesn't the strength of the case affect the likelihood that someone would plead guilty or not? In other words, if it was a really strong case, then you could be looking at this differently than if it was a really weak case. And so the strength of the case is relevant to that.
But who knows if it's a really strong case? It's only DNA. We don't know what the trial attorney could have done with that evidence had he properly counseled Mr. Smith and Mr. Smith said, no, I want to go to trial. Then the trial attorney starts figuring out ways to attack the DNA, which lawyers do every day of the week in trials. So we don't know how this would have come out just based on DNA. And so we would ask that you reverse the trial court's decision. And I'm actually asking that you just reverse it and vacate the plea because it's still our position that it was up to the government to put the trial attorney on the stand or provide evidence about what he did to disprove Mr. Smith's claim. And then in the alternative, if you don't agree with me on that, then I ask that you vacate the order and remand for a new trial. I'm sorry.
Thank you, Ms. Persico.
Evidentiary hearing, I'm sorry.
We understood. Thank
the
you.
second
Ms.
point.
Persico, thanks to you. Also, Ms. Heffernan, the case is submitted. Thank you.
Thank you.
And you both can exit.
Thank you.
Good morning. Our next matter is number 20 CV 0325 Bell versus First Investors Servicing Corporation. I saw Ms. Dennis, only now I don't. Let's see if we can get her back. Mr. Dickerson, did we lose
Our
Yes, we
appellant?
did. I'm going to give her a call. I'm going to wait until she appears on the screen, but on the Zoom. But I have her number right here.
All right.
Let me give her. Thank you.
My apologies, Your Honor. I got exited
Oh,
out.
we're glad to have you back. Hello again. I called the case, and as soon as you are ready, you may proceed.
Okay. May it please the court. Good morning, Your Honors. May it please the court. Roddy Dennis on behalf of the appellant, SHUN Bell. I'd like to reserve 3 minutes of my time for rebuttal. Your Honor, this is a case about res judicata, and the trial court below committed 3 reversible errors. First, by failing to apply the court's on-point precedent, Smith v. Greenway Apartments, which recognizes permissive counterclaims as an exception to res judicata. Defendant concedes that Ms. Bell's claims are permissive. Defendant's sole argument is that res judicata bars both permissive and compulsory counterclaims without distinction. And defendants maintain that position throughout its appellate briefing. Therefore, the narrow question before the court is whether res judicata bars all claims without distinction, which is a question definitively answered by Smith v. Greenway, which relied on section 22 of the restatement, and also the Supreme Court supports that position. The trial court also committed reversible error by failing to look at the judgment as the basis for the res judicata bar. First Investor's judgment is based on the breach of the settlement agreement. Like Judge Kravitz's Oaks management decision, Ms. Bell was never asked whether she wished to give up her right to raise a defense or pursue counterclaims against First Investors before she signed the agreement. And the settlement agreement itself shows no meeting of the minds on either point. In fact, the merit of First Investors' claim is not even referenced in the settlement agreement at all, or the judgment enforcing the settlement agreement. The trial court also committed reversible error by failing to put First Investors to its burden of arguing and proving all the elements of the asserted res judicata defense. It is defendant's burden to argue and prove the defense. Defendant failed to meet that burden, and the court had an inadequate basis to render its decision, barring Ms. Bell's claims. First Investors' brief contains a dispositive concession that the trial court found that res judicata bars all claims without distinction between permissive and compulsory counterclaims. However, the very definition of a permissive counterclaim is one that may be brought in a later separate action. And First Investors' concession that the trial court concluded that res judicata bars all claims regardless, and its sole argument that nullification its sole argument that the nullification or impairment exception is inapplicable to a res judicata analysis makes a prima facie case for reversible error.
Well, I think, Ms. Dennis, that this court has an obligation to read the cases for herself and to see what they stand for. So I'm a little puzzled by your use of the term concession. Tell me again, please, what is the concession that you think First Investors made? The fatal concession?
Well, I guess when they basically said that the trial court, and that may be presumptive on my part, so I apologize, Your Honor, but they say that the trial court barred all claims without distinction between permissive and compulsory counterclaims. And I was under our argument is that Smith v. Greenway actually answers that question.
Well, Smith v. Greenway holds that there are claims about housing conditions that could be brought even though they were not brought in an earlier landlord-tenant action, but it very specifically carves out
the months, I think there were 4 months, but the number's not important, carves out the months as to which judgment was entered. So there was no ability on the part of the tenant in that case to go back and make a claim for some abatement in rent for those particular months based on housing code violations. So I would say that Smith v. Greenway is a problem for you rather than supporting your position, because your case involves a discrete sum of money, this $8,000 and some change relating to the balance due for this vehicle. And what you have is a judgment essentially saying that First Investors was entitled to collect that money. Now you have your client's complaint asserting that for various reasons, it was not entitled to collect the money. And it's kind of analogous to those 4 months in Smith v. Greenway. You can't have a judgment as to those months and then say that some fact makes it improper to collect the rent for those months. So how do you distinguish? Well, I think the cases are distinguishable, that this one seems to fit into that exception in Smith v. Greenway, or into that 4-month category. Why is that a wrong conclusion, if it is?
Well, I would say that, for one thing, I can distinguish the two cases. The Smith v. Greenway case involved confessions of judgment. This is a settlement. This is a private settlement agreement that was entered into between the parties.
And followed by a judgment, because First
correct,
Investors applied for judgment.
Correct.
Got it.
Applied for judgment on the enforcing the settlement agreement, not on the merits of the claim. So the parties entered into a settlement agreement on the first day that at the first hearing.
Well, not on the merits of the claim, in the sense that there was some examination of every possible objection that could have been raised to recovery of the funds. But does not the judgment stand for the proposition that First Investors was entitled to collect the money? And essentially, your client's complaint is that for various reasons, failure to give the notice required under the Automobile Financing Act, for example, it was not entitled to collect that money, which it seems squarely at odds with the judgment.
Well, my client's claims are actually based on First Investors methods, and basically for First Investors violations of the law. It's not basically the law says that certain aspects of the repossession laws, you have to give certain notice. If you do not give notice, you actually violate the law. That's
right, and you're not entitled to collect. That's a statutory
cause of action, as opposed to, so she's not, this is not a situation where my client is seeking retribution for the money that she's paid. She admits and concedes that is a valid judgment. She is not questioning the judgment at all. What she has done here, and it's consistent with Restatement Rule 22 relied on in Smith, is she is raising counterclaims with respect to actual statutory causes of action. I believe that Mercourt also touches on this as well when it says, let me see. It says that basically if a counterclaim makes up both a counterclaim and a defense, the defendant in the first action is not barred from bringing the actual counterclaim. It's a permissive counterclaim, and it's not barred from bringing the permissive counterclaim at a later date.
Ms. Dennis, can I just, I think I understand what you're saying, but I just want to repeat it back to you. Are you saying that it's not what FISC did, it's how they did it?
Absolutely.
And so are you saying that, say they had repossessed her car and then she had, outside of the courts, gone to them and paid them the money and gotten her car back, you're saying she could have then filed a suit saying, sure, I owed them money, but the way they went about this was wrong and violated consumer protection laws and other things. And and nothing about me conceding my liability to them. The fact that I owed them money undermines those claims. That's what you're saying?
That is exactly what I'm saying. Much more eloquent, but exactly what I'm saying, Your Honor.
I'm just trying to use small words for myself.
Yes, Miss Bell is actually bringing action against First Investors for the way that they actually went about collecting the debt by filing false affidavits. These are collection methods that are prohibited by DC law. Debt collection methods that are prohibited by DC law. You can't tell a false, you can't, well, with respect to the repossession laws, Title 16 actually makes any violation of any law in the municipal regulations is a deceptive trade practice. So that,
but according to the complaint, the false claim is that she owed this money. So in Judge Easterly's example, she is conceding that she owes the money, but she doesn't like how they went about collecting it. But her complaint here is that they falsely said she owed the money. How is that claim not barred by res judicata? Because holding that the claim that she owed the money was false seems squarely to conflict with, impair, nullify the judgment that they were entitled to collect the money.
Well, with respect to that particular situation, the method they use by actually misrepresenting to Miss Bell, the act of misrepresenting to Miss Bell that she owed the money is the actual violation of the law. So not the actual, she's not, as I said, this is not a judgment. This is not a judgment execution hearing. This is a judge enforcement hearing, I'm sorry. My client is also not seeking restitution on the money that she has already paid under the judgment. What she is seeking statutorily defined damages as a result of First Investors violating the law. Basically saying, charging, basically the rules say that, for example, that that the repossessor cannot charge more than $100 for retaking and storage fees. That is a violation and a deceptive trade practice under DC law. Just charging more than that is the actual violation. And so it's any sort of debt collection, any sort of false claims made with respect to the amount owed, regardless of whether or not the debt is valid or not. It doesn't matter whether, even if it's valid or not. If you make a false claim about the debt itself, that in itself is a method of collection that is actually prohibited by under DC law, under the DCL.
Now, how does that square with the Greenway case? Because you could say that about housing code violations too. You could say, yes, the landlord got a judgment against me for those 4 months in 2014, and I've paid it, and I'm not trying to impair that judgment by raising housing code violations with respect to those 4 months. But the housing code requires decent housing for people. And my claim is that my house was not decent. I had vermin, I had leaky ceilings and peeling paint. It was a terrible premises, and I'm entitled to recover damages for what I had to suffer in my home at the time. But Greenway says, no, there was a judgment for those months, and you don't get to raise those. You can raise these same claims with respect to prior months and subsequent months, but not those months. How is that different?
Well, I believe in Greenway, she was seeking to reduce the amount of rent that is owed. Here, Miss Bell is not seeking to reduce the amount that she owed in the debt as the debt that she paid. She's seeking statutory damage under statutorily defined damages under the CPPA, the DCL, and also abusive process. So that it's different in terms of what the actual relief that is being sought by each of the different plaintiffs in that case.
Go ahead.
I have a thought in response to Judge Thompson's question. I mean, I could see, say FISC had said, you owe us $20,000. And your client thought, that's crazy. I don't know that much. I owe 10 and I will pay you 10 and I will settle for 10. And then, FISC gets the judgment for 10. But then your client wants to come back and sue and say, they were saying that I owed, twice as much as I actually did, and it was, it was bullying, it was oppressive, and it was illegal. And so it seems to me like that could be a way, right, that sort of, I think maybe aligns this with Smith, but my question is, does the record support that in this case? I mean, part of what I've struggled in reviewing this case is that we don't seem to have very much in the way of the record, right? We have your client's complaint in this case, but we don't have the complaint in the case that was settled. And so I'm just wondering, if sort of my line of thinking is actually supported by any kind of record evidence in this case.
Well, the actual, I believe it is in terms of, the actual record says the stipulation settlement is basically, it does not have anything with respect to any of Ms. Bell's. There's no merits contained in the actual settlement, in the settlement agreement. That is also
right, and that's sort of my point, is that we don't see the distance between the initial complaint by FISC to see where the movement is from that complaint to the actual settlement. I mean, did she settle for as much as they said that she owed, or did she settle for some amount that was less? I'm not sure that we know that, given the record that we have before us.
I believe, I'm not sure, I can't remember exactly what the settlement amount was for. It may have been the same as in the settlement agreement. The amount, so the complaint, as far as the complaint is concerned, I am not sure if it could be the amount in the complaint could be the actual amount in the actual settlement agreement, if I remember correctly.
Let me just ask a follow-up, Ms. Dennis, about the record. You also argue in your brief that the appellant has fully paid and satisfied the judgment. Is there anything in the record to support that argument?
There is nothing in the record, but the other side did not dispute that claim when I made it below.
Let me ask you about the Oaks case, Ms. Dennis, which you rely on heavily. And that, of course, is a ruling by one of our Superior Court judges, Judge Kravitz. I can't recall whether in the briefs you cite any case other than Oaks for the rationale that Judge Kravitz applied there, which is that notwithstanding consent judgment, that there was a sort of a reservation of rights to raise consumer protection claims. Do you have another case that supports that proposition?
In terms of there's general contract law that says that you interpret what is actually in the agreement rather than what you might have wanted to look in the agreement. I believe I cited.
How does that help you? Seems like your client would have wanted the agreement to reserve consumer protection rights, but it certainly didn't do so explicitly.
Well, any relinquishment or waiver of consumer protection rights must be clear and intentional according to Supreme Court precedent. So it was not up to my client to reserve rights if the actual agreement between the two private parties does not actually contain a waiver of rights or relinquishment of rights. Then it can't. It is hard to see how the court or how it can be implied or inferred that such when the parties entered into a private. I believe actually it would be extraordinary to actually insert terms into an agreement that are actually not there. My clients read, as a pro se litigant, my client read the agreement, and what it said was it didn't say anything about waiving any future claims or anything like that. And actually, First Investors actually drafted the agreement, and they're the ones who were represented. Their counsel drafted the agreement. So obviously it should also be construed against them as opposed to construed against my pro se client who was not represented and is the unsophisticated party in this situation. And that's also how it's similar to Oaks Management v. Smith.
Ms. Dennis, I'd like to just veer to a different topic, which is in the appellee argues in its brief that Maryland law applied to Ms. Bell's contract, not DC law, and that provides an alternative basis for upholding the dismissal of the complaint. You argue that the trial court rejected that argument that Maryland law applied to this case, and I just didn't know where that was. I guess my question for you is, did the trial court explicitly reject the Maryland law argument, or did he simply not address it?
I believe he simply did not address it, Your Honor.
Okay.
But the fact that he went with res judicata, I believe that the defendant's claim on applying Maryland law is meritless in terms of because for one thing, they haven't proven that they have a contract. Their name is not on the contract. None of that information that they are arguing in their brief has actually been proven. It's basically just assertions and the defendant's own self-serving representations with respect to the contract. Not to mention the fact that in terms of the case that defendants are relying on, Chamberlain, that used one of two definitions with respect to what is considered, when the Title 16 actually applies in this case. And the other definition is the one that applies in this situation. So basically, the defendant's choice of law argument, and I believe that the trial court probably read it and came to the same conclusion, is not supported by the law. Or the facts for that matter, because there are basically defendant also has they're not supported by the facts because the First Investors and the actual auto dealer both are licensed in the District of Columbia. And that's a matter of public record.
All right, thank you, Ms. Dennis. We'll give you a few moments on rebuttal if you need them. Let's go to Mr. Ross now.
Thank you, Your Honor.
Good morning, Your Honors. Thank you for the opportunity to speak to the court. David Ross from Wilson, also on behalf of the appellee, First Investors Servicing Corporation. I think it'd be helpful to take perhaps a step back. You had a very effective and engaging colloquy with Ms. Dennis on certain aspects of this case, but just to take a step back and look at the landscape. I mean, Ms. Bell appeared in DC Superior Court. She appeared in front of the DC Superior Court's mediation program. They had a mediator. She had the settlement completely explained to her by Judge Brenneman. That's on the record in the underlying case. Judge Weidman specifically said that you had all your rights explained to you during the process, as is the normal standard course in the DC Superior Court mediation program. You then entered into the settlement. It was for the amount that was sought. It was for the $8,200 approximately that was sought in the complaint filed in DC Superior Court. She agreed to make $150 per month payments, and she did.
Is that in our record? Yeah, I mean, you're telling us that, but is that record information? That the settlement was for the amount sought?
Underlying record. It's in the underlying record. It was presented to the trial court. The trial court had it in front of it when it's rendered its decision. Whether or not that has been presented to this court, that I don't know. It was not included in the joint appendix that the parties presented to this court, but it is a matter of record.
Or is it in the record? And when you say it was presented to the trial court below as an exhibit, I mean, as an attachment to a pleading, how was it presented?
It was presented as an exhibit to. And first, I apologize. There was some buffering. I'm not sure if it's on my end, and I apologize. And I see the screens have gone blank for several.
Oh, well, I was going to suggest that we all mute ourselves. I'm seeing everyone. You cannot see us?
I can see you now, and I just want to make sure you can hear me.
I can hear you, yes.
Okay, thank you. I apologize. We had some buffering there. The stipulation of settlement was included as an exhibit to First Investor Servicing Corporation's motion to dismiss that was presented to the court below. And so
We have the settlement agreement, but to the extent that you're representing that the settlement was for the amount sued for, do we have the underlying complaint to that? And I didn't see that in the record materials. And was that presented to the trial court?
the answer is yes, it was presented. I do believe that was indeed the first exhibit, or certainly one of the first pages of exhibits that was included with the motion to dismiss. And in that motion to dismiss, it was the statement of claim that was presented to the Superior Court in connection with the initial filing of the case against Ms. Bell by First Investors. And in that, it specifically states the 8,200 approximation. And then, of course, in the stipulation of settlement, it then replicates that amount, and Ms. Bell agrees to make the $150 per month settlement agreement. So that should be in the record. That's in front of this court, and it certainly was as part of the record that was presented to the underlying court in connection with First Investors' motion to dismiss. And of course, Ms. Bell did indeed begin to make her payments. And she made $150 monthly payments, but then the following year, so she made this settlement in 2017, in 2018, Ms. Bell fell behind her payments, and as this court is aware, that a judgment was subsequently entered against her, roughly in the amount of $6,200. She had obviously brought the balance down by making payments, and the remainder amount was entered in as a judgment against her. And then, of course, several months later, Ms. Bell then raised essentially the same claim she's raising here. I mean, if you do a comparison of the claims she attempted to raise in the underlying case, they're essentially the same claims as she raised here. And she attempts to do it on a putative class-wide basis. And then, of course, the court below rejected it, both on a motion to vacate the underlying judgment. And then, of course, she attempted to seek judicial review. And then, of course, she attempted to seek appeal before this court. And all attempts, of course, the judges denied her efforts. And then, of course, we have the recasting in this case. And we have.
Can I ask you a question? It's sort of the same question I asked Ms. Dennis. I mean, say Ms. Dennis, say Ms. Bell had purchased this car, had failed to make payments, that she settled, and that she continued to pay and paid everything that she owed, but then subsequent to paying off the debt, but still within the statute of limitations, she turned around and sued you all and said, but you all did all of these underhanded things. You charged me for, fees related to storage, and you gave me these notices that weren't compliant with consumer protection statutes. And would you say that because of the settlement agreement that she was not able to bring those claims separate and apart from her, owing a debt to you?
As a threshold matter, just so the court's clear, that's not what happened here. As we all know.
I understand that I am possibly posing a hypothetical. I'm just asking what your answer is to the legal question.
Right. Under the hypothetical that you posed, I think the argument would be presented that yes, by entering into a settlement agreement, you agreed that if you didn't make your payment on time, that First Investors could get a judgment against you. And to encourage settlements, we want to make sure that settlement agreements shall not be modified. And in doing so, you were giving up your rights to litigate.
But what about the settlement says anything about consumer protection claims? Right? I mean, and I guess sort of what law do you have to say that we would construe a settlement agreement that expansively? Because that seems pretty expansive to me.
You can look to the Molovinsky case, Molovinsky versus Monterey Co-op at 689 Atlantic 2nd, 531. And in that case, this court specifically found that a res judicata applied because of a small claim suit that the plaintiff settled. And the court specifically recognized that under the doctrine of res judicata or claim preclusion, a final judgment on the merits embodies all of a party's rights arising out of the transaction involved, and the judgment stops not only as to every ground of recovery or defense actually presented in the action, but also as to every ground which might have been presented. And then to your specific question, that was raised in Molovinsky. And so Molivinsky, and here's what the court says in the case, Molivinsky makes an alternative argument that in settling the case, the parties agreed that he could pursue his claims in the Superior Court. However, the settlement agreement is absolutely silent on any reservation of rights, and no other written document was proffered by Molivinsky. So in other words, the court there said, you don't have to come up with some sort of a Hobson's choice to try to do an exhaustive laundry list of every possible legal claim and put it in a settlement agreement.
Does it matter that Molivinsky was the plaintiff?
The legal principle does not matter. Because the legal principle is if you don't reserve the rights to seek later relief, well, we're going to construe it as if it's a waiver. In other words, you don't have to have a lawyer trying to come up with, conjure every possible legal argument someone's going to later raise and try to recast the claims against you. The court reasonably found that, no, if you want to preserve rights, you preserve rights. But we're not going to simply take a settlement agreement and try to squeeze it out like a sponge to see if perhaps you left out a possible claim that someone could recast and later try to pose against you in a later lawsuit, despite the fact that you're trying to have finality here and you're trying to apply clear principles such as it's embraced in res judicata.
It just, Molivinsky, I'm not sure supports, or I'm not sure it addresses my hypothetical where there's a separation between the debt and the procedural claims. It seems to me that in Molivinsky, that it really is all about kind of how much money was owed, and it all seems of a piece. So I'm not sure that I'm seeing that Molivinsky is helpful to you in answering the hypothetical that I posed.
Well, let's just trace back to the actual contours of this case. This case is all
I really don't want to talk about the contours of this case. I'm trying to get a legal answer on my hypothetical.
And again, the legal answer, I believe, with that would be yes. The settlement agreement would be enforceable, and you would have waived your rights to seek those claims.
How is that consistent with Smith? I mean, there was no agreement in that case which preserved the defendant's right to maintain or to bring an action based on housing code violations. So I guess I'm just wondering how is that argument consistent with Smith?
Sure. So a couple of steps back. First, keep in mind that Smith v. Green was not raised with the court below on motion to dismiss, but we're discussing it now. Second thing is keep in mind the unique contours of the landlord-tenant rules. And so, of course, in landlord-tenant rules, you have Rule 5 of the landlord-tenant rules. That specifically says under Rule 5B, under the landlord-tenant rules, and it's entitled counterclaims. And it says, when permitted. In other words, under the landlord-tenant rules, there are times you cannot bring counterclaims. It's specifically prohibited. And in that rule, it says in actions for recovery of possession of property, in which the basis of recovery is non-payment of rent, or in which there is joined a claim for recovery of rent and arrears, the defendant may assert an equitable defense of recoupment or set-off or a counterclaim for a money judgment based on the payment of rent or an expenditures claimed as credits against rent or for equitable relief related to the premises. No other counterclaims, whether based on personal injury or otherwise, may be filed.
Wait. So you're arguing that Smith versus Greenway is limited to actions brought in the landlord-tenant branch?
Absolutely.
Even though the rationale for permissive counterclaims in the landlord-tenant branch seems to apply just as much to small claims, which, just like landlord-tenant, is meant to provide a forum for the speedy and inexpensive determinations of each action. In fact, Rule 1 of the small claims rule is identical to Rule 1 of the landlord-tenant rules. And also, Rule 2 doesn't allow or doesn't provide for compulsory counterclaims. So I don't understand how Smith versus Greenway can be limited to landlord-tenant branch if the rationale in Smith versus Greenway seems to apply just as much to a small claims action.
The rationale, the difference in the rationale is, of course, one is going to be your non-payment of rent. The other one is, of course, going to be living conditions. And so what the legislature deemed to seem fit, it was to create a specific counterclaim rule, which was then applied in Smith v. Greenway. Not applicable here. There is not a counterclaim rule in small claims court that has any equivalency to Rule 5B of the landlord-tenant branch, which explains.
Wait, let me follow up then. Are you, because I want to see where there's agreement between the parties and where there isn't. And I thought I heard earlier, and maybe this is not correct, that there was agreement between the parties that this would have been a permissive counterclaim. Do you disagree with that argument?
That's never been a concession that's ever in the record whatsoever. That's just something.
We're asking for your position right now.
No, we think in this essence, it wouldn't have mattered. It was compulsory permissive because res judicata encompasses both. B, it was a compulsory counterclaim. She had to bring it in the underlying case below.
And what is your basis for saying that it's a compulsory counterclaim?
Because it has a direct correlation, a direct factual nucleus with the contractual dispute that was at issue below.
And what is your basis for saying that that could be litigated in small claims court pursuant to our rules?
Because there's no rule that precludes it. And in fact, the specific rules in Superior Court small claims, Rule 5 says this: small claims court procedural rules say, pleadings, no party is required to file an answer, plea, or defense in writing, except to assert a set-off or counterclaim. So in other words, there's nothing there that says you had to do this, or you didn't have to do this. So it says no party is required to file an answer, plea, or defense in writing, except to assert a set-off or counterclaim. Keep in mind, Smith v. Greenway was decided over 5 years ago. It has never been cited one time by any court as some sort of an exception or a recognition that res judicata applies to permissive counterclaims.
By any court, do you mean our court? You know, I mean, you know, cases come up and, 5 years just doesn't sound like that long to me. I have no idea what's going on in Superior Court and whether they're relying on Smith or not. They may be citing it every day, and no one is appealing to us. And if they don't, then you're not going to see it in our case law. But I can't say
small
that.
Claims Rule 13 specifically does not, well, the small claims rules specifically don't adopt Rule 13, which is the counterclaim rule.
Exactly. It is not
We
adopted.
actually have some case law saying that, what is the name of the case? Weaver, I think, that there are no compulsory counterclaims in small claims court. So I think the better point here is that these were not compulsory, they were permissive. And the question really is the rule that's stated in Section 22 of the Restatement of Judgments, whether there is a impairment or nullification of what you obtained through the judgment. Is there? If her claims proceed?
There clearly would be. And the reason.
And let me just, I'm sorry, I just want to interrupt for 1 second. And before, just with respect to, it's a follow-up to Judge Thompson's question. And I just want to make sure I understand factually. The appellant has claimed that they have fully paid and satisfied the judgment and that you did not counter that assertion. Is that correct? You don't disagree with the appellant's assertion that the appellant has fully paid and satisfied the judgment?
We are not disagreeing with that assertion. That's
okay.
Correct. But going back to the point, if you look at the specific allegations in the amended complaint, regardless of the creativity of counsel in drafting briefs before this court, you have to look at the specific factual allegations in the amended complaint. And it's inextricably intertwined with the specific contractual issues that were confronted with the court below. There is a common nucleus of operative facts, and that's why case after case, the cases that Judge Lopez wisely cited, Patton v. Klein, and the case law that's out there clearly says res judicata applies to claims. It claims that you could have raised and claims that you didn't raise but could have. And all that
Right,
matters.
but I guess, the concession that you just made to Judge Oken really kind of cleaves this common nucleus for me, because it seems like there's the money she owed. She's not arguing about that anymore. She's just arguing about the process and the compliance with consumer protection laws. And maybe she loses on those. Maybe she's all wet, right? And she has, she will not be able to prevail. But as far as just dismissing her claims on res judicata grounds, that seems really hard to do. If you're saying, okay, how much money I owed FISC has nothing to do with this. I settled that and I paid them and that's over and I agree, right? This is about something else.
Two responses. First, That's not what the amended complaint says. Again, we need to go back to what the amended complaint says. It's clearly tethered to the amount that was owed under the vehicle contract. That's inescapable. Second is, if you want to establish a standard where res judicata no longer applies when someone resolves or pays off a judgment, well, you're going to eviscerate the finality of settlements, and you're going to invite a whole host of Pandora's box issues.
Or we're just going to promote the better drafting of settlements.
I respect. That may be a witticism there, but I think that you're going to open up a Pandora's box more than you realize if you go down this road, because clearly the facts of this case don't support it. I mean, maybe you want to make that argument or ruling in a different case with different facts where it's actually properly presented, but in this case, respectfully, that's not what's before this court.
It does seem that the allegations in the complaint here are about misrepresenting that the amount owed was owed, rather than broader consumer protection claims. Is that the point you're making?
That is precisely the point. One need only take a look at the joint appendix and the actual factual allegations. It's specifically titled Allegations Common to All Causes of Action. It mentions the purchase of the vehicle. It mentions the inability to make payments on the vehicle. It mentions the amount sought for the vehicle contract. This is specifically what we're talking about here. It's on point. This is a textbook example of where res judicata would be properly applied. And no court has ever recognized an exception or exemption from res judicata as Ms. Dennis and Ms. Bell seek this court to apply today.
Right. She says in the allegations common to all counts that FISC failed to advise the plaintiff that she had no right to the deficiency amount, misrepresented she was obligated to pay the deficiency amount, attempted to collect a deficiency barred amount, falsely represented the amount of the debt. Well, she says other things in the complaint, so we'd have to look at that carefully, but I understand your point.
And keep in mind that generic allegations that don't have any factual contours with them are not entitled to any gravity before the court. So I think you'll find in there not a single date, not a single method of communication, no specificity whatsoever in the factual allegations to support any recasting of these clearly contractually tethered allegations to debt collection. It's not any
Ms. Dennis seems to argue that this, your argument about Maryland law and whether or not First Investors is licensed in the district raises a lot of factual questions that are not resolved in this record. Do you have a response to that?
Understood. First, the court below did not address it because, as courts are wont to do, when it found a grounds to rule dispositively on a case, it rested on those grounds. So the court below did not need to address it. It was raised below, but the court said, res judicata applies. I don't need to address the other arguments that FISC or First Investors raised in the motion to dismiss. But no one has ever contested the existence of the contract, and clearly the contract Ms. Dennis signed specifically elects Maryland's consumer grantor credit, closed-end credit grantor provisions to apply, or in other words, collect for shorthand. That's not really in dispute. That's not, and if you look at the contours of the actual contract itself, it clearly says she went into Maryland, she bought it from a Maryland dealer, she elected Maryland law to apply. So, and the entire premise of Ms. Bell's allegations against First Investors is, well, you violated DC law. Well, of course, the reasonable response is the contract you're saying we violated specifically states Maryland law applies. And you never contested that First Investors wasn't properly assigned the contract. That was never raised below. So this just further goes into the Pandora's box if we allow res judicata not to be applied.
Well, the contract that's in the record has a different name on it. It seems to have the name SHUN Bell, but a couple of other names before it. So I don't think the record tells us why there was that discrepancy.
Correct, and wouldn't. It obviously wasn't developed below. The motion to dismiss was filed, granted on res judicata grounds. So the record was not developed on that construct. No, that's correct in that regard. But it's clearly, but the contract clearly states Maryland law applies, and Ms. Bell did not contest below that she actually owed, and Ms. Dennis has conceded during the arguments today that Ms. Bell owed the money on the contract. She has said it repeatedly during the arguments today that Ms. Bell owed the amounts on the contract. And
I think she just said that she's paid it and she's not fighting about that anymore. But
She says she's
it
not
seems
telling
to me, is there a reason that, I mean, the question of law could be litigated on a remand, right? I mean, there's no reason that it would have to be resolved right now, especially if the trial court didn't address it.
There'll be no reason to do that. Again, it's an alternative dispositive means of resolving the case. The court
That
found
the trial court didn't reach, right?
correct. So the trial court didn't need to reach because it resolved it on res judicata grounds. I mean, that's standard fare for any court that's going to be presented with arguments A through F on a motion to dismiss, and A dispose of the entire case. Well, rarely will a court go through, B through F if it's already resolved it on A. I mean, they want to preserve judicial resources as much as we can nowadays. So that's not unusual, certainly, and it's not any indication that there was need to be remand, something that's already fully resolved in a resolved motion to dismiss and a resolved case under res judicata. Again, it's under the same rubric. It doesn't really matter now. The case is over. It's resolved. Res judicata was properly applied by the court below. Her claims were deemed to be not permissible.
To be clear, I was saying if we disagreed with you on res judicata, we would not have to reach the question of law. That's what my question was.
I think you could. I mean, that's why I raised it as an alternative.
We could, perhaps, although Judge Thompson raises some record questions. So it seems like maybe it might be best for remand if we were to remand.
It's sufficient enough to resolve even that issue as an alternative means of holding the judgment, but I understand your point, Your Honor.
The complaint raised a claim for damages, I think punitive damages, compensatory, statutory damages, but also included a prayer for a declaratory judgment. Does that end with the end of an action for damages? I mean, is it clear that when there was a dismissal on res judicata grounds that it covers a declaratory, the prayer for declaratory relief as well?
I think it fully resolves Ms. Bell's claims, regardless of how they are styled. Keep in mind, res judicata specifically says in case after case, what matters is the factual nucleus, not your claims for relief, not your theories, not how you try to recast it. If res judicata applies, it applies. And that's the beauty of res judicata. We want finality. And once it applies, it doesn't matter how creative you get in your claims for relief or the causes of action. If it applies, and the case is settled, and finality is once again reinforced in the application of the law.
I haven't looked at this, Mr. Ross. I think the law is that if the claims of a putative class representative are dismissed, including on res judicata grounds, that takes care of the class claims as well. Is that your understanding of the law? Was there something left of this case for the class, even if not for Ms. Bell?
The general rule of thumb is that class claims are told during the pendency of an action. So in other words, if a putative class member wanted to go ahead and seek redress against first investors, their claims were likely told during the pendency of Ms. Bell's case. Once the case is resolved, then of course the statute of limitations starts anew for those individuals. So the answer is, if those individuals have timely claims, her resolution on an individual basis would not impair the ability of putative class members to seek relief or redress against first investors.
But not in this action.
Correct. Of course, not in this action. Yes, to seek any separate action. Of course, that's correct, Your Honor. And that's general class action law throughout the nation.
Anything else you need to tell us, Mr. Ross?
Other than thank you for your indulgences. There's some buffering issues, and thank you for your time this morning. And I do thank you. And if you have further questions, I'm happy to answer them. But thank you for your time, Your Honor.
Thank you. Ms. Dennis will give you a few minutes if you need them.
You're muted, Ms. Dennis.
Yes, you are muted.
Sorry about that. I would first like to address Miss Bell's allegations. Ms. Bell actually alleges that she was never notified that in number 11 of her allegations is that she was never notified that that first investors intended to repossess a vehicle. That's a violation of Title 19, as well as Ms. Bell was never notified that the vehicle had been repossessed, nor was she notified where she would be able to collect her personal belongings. Both of those are actually violations as well. In terms of and I also want to say that defendants did not rebut Ms. Bell's argument below and made no arguments relating to nullification or impairment. But I do want to just explain to the court with respect to the case Mercoid and Section 22 of the restatement, which distinguishes between a defense asserted to attack a judgment and counterclaim for damages. With respect to a defense to use to counterattack attack a judgment, that is actually barred. But a counterclaim, a separate statutory action, Mercoid says it can be brought. Says where the same facts may be asserted as either a defense or a counterclaim, and the issue raised by the defense is not litigated and determined so as to be precluded by collateral estoppel, the defendant in the previous action is not barred by res judicata from subsequently maintaining an action on the counterclaim. That's Mercoid. That's also, I believe it's County of Sacramento, Kroll, the County of Sacramento as well, Supreme Court case. Here, this is a counterclaim, a statutory action. Mercoid's the Supreme Court case says, and so also Henderson, this court's en banc decision in Henderson states where it actually barred the fraud claim, which was asserted as which could have been asserted as a defense in the first action, but allowed the misrepresentation claim as well as the breach of fiduciary duty claims. Both of those claims were allowed in the en banc court because they were separate statutory causes of action. Here, Ms. Bell's claims are separate actions, separate statutory causes of action that have that damages attached thereto. Also, with respect to the settlement, Whiting, the defendant's cited authority, had in its drafted in its agreement, in its settlement agreement, that the individual could not actually basically made the settlement agreement specific to the claims that the claims that were brought in the second action. So it is possible to draft a settlement agreement that actually includes a waiver or relinquishment of rights. That's what, and I think it would be unfair to Ms. Bell, who is, as I said, a pro se defendant in this case, and defendant was a sophisticated plaintiff who was represented by counsel and drafted the agreement, did not include those things inside of its, like Whiting, its cited authority, did not include that information inside of its agreement and inside of its settlement agreement. And so to now expect Ms. Bell to have known that, there's no way she could have known if it's not written there as a pro se defendant. If it's not written inside the agreement, how could she deliberately and consciously assent to a term that is absent from the actual agreement itself? And in terms of Molovinsky, I think the court was speaking with respect to Molovinsky. Molovinsky made the claim that he had, first Molovinsky, like Judge Easterly said, brought both the first action and the second action, and then made a claim in the second action that he had reserved his rights. And the court simply stated that no, there's no reservation of rights in this actual claim. Molovinsky actually said, I told them that they said it was okay, something along the lines of, they said it was okay that I bring the second action. And the court then said, well, there's no reservation of rights here. So it doesn't say that there's no language in here saying that. And basically what the court did was actually look at the agreement itself to make that determination. And also, as I said, with respect, Molovinsky also, as I said, says that the counterclaims, there is no compulsory counterclaim rule. Weaver v. Graffio also says that there is no compulsory counterclaim rule in small claims court as well. I believe. Oh, and defendant also discussed the Rule 5, I believe. But that rule specifically says that that information must be filed in writing. So it's a counterclaim. If a counterclaim is, it's not compulsory. It says if a counterclaim is filed, it must be filed in writing. Was another. So it's not a compulsory counterclaim rule as presented by the defendant. And as I said before, with respect, the judgment speaks for itself, and it to actually read, to expect Ms. Bell to know that she is waiving her defenses and any future counterclaims against First Investors by looking at this agreement. There's no way that she made a conscious decision not to actually a conscious decision to waive or relinquish any rights with respect to this case. There is no merits determination. There is no merit determination in the actual settlement agreement. There's nothing in the agreement. All there is an agreement for Ms. Bell to make payments, and she consented to an application of judgment. That's what Ms. Bell read as a pro se litigant. She couldn't read anything else. The rules also say that it's not required that you bring a compulsory counterclaim. If the rules say that you don't have to bring up a compulsory counterclaim, and not only that, with respect to the rule 2, it not only says that, but then it decimates the actual trigger required to actually file. The small claims court does not require you to file an answer. So the court board of judges actually decimated the actual trigger for actually that makes the mandate to file a claim. So if you don't have to file an answer, how on earth do you trigger Rule 13 or a compulsory counterclaim rule with respect to that? So as I said before, Ms. Bell should not be treated any differently with respect to Ms. Bell should not be forced to, or FISC should not be allowed to put into its settlement agreement things that they did not include in their agreement when they signed it initially, and they should not have. And the court should not actually use this opportunity. Well, the court, it's unfair to Ms. Bell if such terms, new terms, are actually read into an agreement when the agreement she signed is not what FISC is purporting it to be. And with that, Ms. Bell respectfully requests that the case be reversed, the trial court's decision be reversed. Oh, yeah, I can't hear you. You're on mute.
Yeah, it would help if I would unmute. Let me try that. I was thanking you for your argument very much. Thank you also, Mr. Ross. And the case is submitted. And you may exit. Thank you.
Thank you so much. Have a great day.
Have a good day.
You too.
This court is now adjourned.